Thank you very much. Firstly, I'd like to thank all of you for making time to come down to this afternoon's session. I know it's although it's only the start of the week, it's almost the end of the conference, and also it's an after lunch session. Anyway, although the theme of this afternoon's session is supposed to be on copyright in the music industry, and I'm not sure how my topic got slotted into this afternoon session, but what I wanted to talk about really is about the issue of time shifting and copyright. And I've asked the question, how relevant is copyright law? And I'm going to talk about not the tale of two cities, but actually the tale of three countries, which is Singapore, the United States, and Australia. Right. We're going to talk about three cases, and the three cases evolve around very similar facts, and this is to do with digital recording of free-to-air TV programs. And at the end of this session, we will, I guess, realize that copyright law may not be what it is supposed to be, and it is always at the end of the day the courts that decide what copyright law, how relevant copyright law should be. Okay. Now, what are we talking about? The old technology is the VCR. The VCR is something that was used to record TV programs when you were not around to watch it. So basically, it was fixed to your TV monitor, and you timed it with the time recorder. When you're not at home at a certain time, the VCR would record the TV program, right? But things have moved on, and nowadays the issue of time shifting really has become more digitalized. So we have such things as internet time shifting. The recording is done digitally and via the internet, and the recording is not done in the home of the user. So, how effective is copyright law against this type of new technology? How relevant is copyright law in the light of this new innovation? And let's see how the courts in the US, Singapore, and Australia have dealt with this issue. Okay, let's first take a look at the US case of Cartoon Network. I'm not sure how many of you are familiar with this case. This case involves Cablevision, which is a cable company that had agreements with various content providers that subscribe Cablevision to transmit a content stream directly to its subscribers. Okay, now what happened here was a system was developed whereby there was digital deep recording of the television of the content stream. It's a bit technical here, but you need to know that there were two streams that were recorded. One that was recorded temporarily and was held, and this data was held for only about a few seconds before it was sent to the server. The server then decided whether or not the content that came to it should be downloaded to a hard disk for onward transmission to a subscriber. Okay, so that's the technical aspect of it. But what is more important is, as a general view, it was a way of recording TV programs or cable programs digitally, and so that it could be replayed back subsequently at a different time. Okay, so what does the U.S. Copyright Act talks about in terms of what amounts to copyright infringement, or what is copyright? Copyright is, under Section 106 of the Copyright Act, is to reproduce the Copyright Act in copies or phonorecords. And in the case of literary or musical or dramatic works, to perform the copyright works in public. Right, so it's very similar in concept to many of the other copyright laws in other countries. The U.S. Act is a bit more complex, And it also defines what is meant by copies, and there is a need for the work to be fixed by any method known or later developed. So there is a fixation requirement for there to be copies under the US Copyright Act. Furthermore, it must not only must there be a fixation, it must be sufficiently permanent or stable to permit it to be perceived or reproduced. So there's fixation and there is some form of permanency. All right? So that is what is required under the US Copyright Act. Furthermore, in terms of performance or public performance, the copyright means to perform or display it at an open place to the public, or to transmit or otherwise communicate the performance to the public. So that's the general concept of what is meant by a public performance of a copyrighted work. So what are the issues in the Cablevision case? Firstly, in terms of the technical innovation, whether briefly storing the data in the first set of buffers, whether or not Cablevision made copies of the protected works and thereby infringed the plaintiff's exclusive rights. Secondly, by copying the programs onto the hard disk, whether or not Cablevision infringed the reproduction right. And finally, whether by transmitting the data from the hard disk to the end consumer or the customer who had requested for the recording to be done, whether or not Cablevision infringed the plaintiff's rights of public performance. So these were the issues that came up before the court in the Cablevision case. How did the US court decide it? Well, firstly, the US court looked at what amounted to copies under the US Copyright Act. And they came to the conclusion that the embodiments of the copyrighted programs were not fixed, at least when it first came in the streaming process. All right, so there was no fixation or embodiment requirement, and there was no permanency requirement. So in the sense of the streaming that was being done, the US court held that there was no copies made at all, right? Because it was so fleeting in that sense. All right, so they dealt with that technical aspect. It's here what the court held. The court held that although the works were embodied in the buffers, the durational requirement was not satisfied because the works remained in the buffer for no more than a fleeting 1.2 seconds before the data was overwritten. So this was a kind of a streaming process. Then what about the hard disk, the downloading to the hard disk? Here, the US court took a very interesting approach. Who made those copies in the hard disk? That was the question that the court asked itself. The court applied what is known as the volitional test or the volitional conduct test and held that it was not Cablevision that made the copies, but the user who had requested for the copy. All right? Now, in other words, what the court said that in the case of a VCR, the operator of the VCR, the person who actually presses the button to make the recording, supplies the necessary element of volition, not the manufacturer, not the person who maintains it, or even whether or not it's a distant machine. I think this is quite well established. So, in the terms of a digital DVR, the court went on to say that a customer is not sufficiently distinguishable from a VCR user to impose a liability as a direct infringer on a different party for copies that are made automatically upon the customer's command. In other words, it was not Cablevision. Cablevision may have supplied the equipment, the technology that provided for the recording to be done, but the act of volition was the end user who actually selects the time of recording, the program to be recorded, and presses or clicks the enter button. That's it, the act of volition. So the end user was the one who made the copies, not Cablevision. Playback. So now we have the court has already dealt with no copies were made during streaming. It wasn't Cablevision who made those copies. Now what about the playback to the end user? Did that amount to a public performance under the US Copyright Act. Did Cablevision transmit the performance of the work to the public as defined under Section 101 of the US Copyright Act? The court held, because each playback transmission is made to a single subscriber using a single unique copy produced by that subscriber, right, such transmissions did not amount to performances to the public and therefore did not infringe any exclusive rights of the public performance. So what the court said was, because the playback was only to the end user himself who had selected that recording, there was no public performance. Makes sense, right? If I recorded it and it's only me who can see it at the end of the day, so there shouldn't be any instance of public recording. So that was the Cablevision case. As you can see how the US court had dealt with this issue. Let's take a look at now the Singapore version of the same story. All right. Record TV was the owner of an internet-based service that allows its registered users to request the recording of MediaCorp's free-to-air broadcasts in Singapore. Same concept. The broadcasts were recorded on an IDVR, internet-based digital video recorder. Right. So you had MediaCorp, the main broadcasting institution, providing free-to-air TV channels, right? Record TV provided a service whereby the end user or any member of the public just needed to subscribe to its services on the internet, log on whenever it wanted to record a particular program, key in the date of and time of the program, and Record TV would then automatically, through the internet, digitally record the TV program. What happened here? MediaCorp said that amounted to copyright infringement. Why? Because under the Singapore Copyright Act, there were certain provisions which seem to protect the copyright owner. And this is very similar, as you will see from the US position. All right? First and foremost, the nature of the copyright allows you to make a copy of the film or to communicate the film to the public. All right? The same concept as public performance or public communication. And the Act first goes on to say at Section 16(6) that a communication other than a broadcast is taken to have been made by the person responsible for determining the content. All right? Now, so it says whoever is responsible for determining the content is the person who has communicated the content, and one of the prohibited acts, if you are not the copyright owner, is to communicate that content to the public. The rest of the provisions here are very, very similar to the concepts in the US Copyright Act and also found in many other copyright acts. We also have in Singapore what we call authorized infringement or secondary infringement, in the sense anyone who authorized the doing of any act, then or if you authorize an infringing act, then you yourself are guilty of copyright infringement. So that is what is known as authorizing copyright infringement. How did the Singapore courts deal with the issue? Or rather, what were the issues? The issues here was the same as in the Cablevision case. Whether Record TV copied the free-to-air shows, whether Record TV had communicated the shows to the public. And because of the authorization provisions in the Copyright Act, the third issue that the court had to deal with was whether or not Record TV had authorized its users to do any act which was comprised in the MediaCorp's copyright, which was mainly to make copies or to reproduce and to communicate them to the public. So it was a twofold attack. Basically, either you were responsible for the infringement, or if you were not responsible for the infringement, you at least had authorized the end user to infringe. So what did the Singapore Court of Appeal decide? Firstly, the court also applied the volition test. It was the registered users requesting for those shows who did the copying. All right? And furthermore, the users in this case, were legally entitled to view and record the programs because they had, all right, let me just rephrase this. This slide is not very clear. Essentially, the court held that the users, because they had a license, a general TV license, they had a license to legally view and record the MediaCorp program. And so, therefore, they were the ones who actually did the recording of the copies, right? So, in that sense, in this case, the Singapore court followed the rationale in the Cartoon Network case. Whether or not, the next issue was whether or not Record TV communicated the show to the public. Again, the Singapore court held that there was no communication of the show to the public, following the same rationale as in the US Cartoon Network case. Firstly, the court held that every registered user or every member of the public has a general TV license, right, and therefore they were licensed to watch any of the MediaCorp shows, all right? So the users, when they were recording, they were also making the request. The recording was done privately and individually and for private use. So on this basis, the registered users were not members of the public, and therefore there was no communication to the public. All right. The rationale is slightly different from the way the US courts treated the issue, but essentially the results were the same. An end user who recorded the programs for his own viewing did not communicate it to the public, neither did it cause the facilitator, in this case Record TV, to have communicated the works to the public. Okay. So this is the court's rationale. The communicate should be interpreted such that transmissions initiated by the recipients, the users, are considered as a form of communication protected under the Act, and that accordingly it was Record TV's registered users who have communicated MediaCorp's free-to-air broadcasts and films. Record TV only provided those registered users with a facility to view the MediaCorp shows which they were free to view at the original broadcast time at a later time. Sorry, there's a typo there. Yeah. Then, what about the fallback argument that if Record TV had not infringed, at least they had authorized the infringement? The court held that authorization liability could only arise when 4 factors are established. Whether the alleged authorizer had control over the means by which a copyright infringement was committed. In this case, all they said was the IDR responded automatically, like to the registered user's command, without any human intervention, just like the traditional VCR. So in this case, Record TV was no different from the manufacturer of the traditional VCR. So in that case, they could not be held to have control or power over the end user. The nature of the relationship. Again, Record TV did not profit commercially from the relationship, although the registered user may have benefited socially by being able to watch TV programs at a later time, right? Record TV only served as a conduit to enable these users to time shift TV programs. Whether the alleged authorizer took reasonable steps to prevent or avoid copyright infringement, Record TV did so. They took adequate steps to prevent infringement. For example, it restricted the use of the service to personal, private, and domestic use. The broadcasts were streamed rather than downloaded, so no copies were made and could not be subsequently redistributed. The registered users could only record programs which they could view legally and record. So the reasonable steps were taken by Record TV to ensure that there is no misuse of the right to record the programs and to watch it only for private and domestic use. And whether or not the alleged authorizer had actual or constructive knowledge of the occurrence of copyright infringement or the likelihood of such infringement occurring, the court held that since Record TV had taken the necessary precautions against copyright infringement, it would not be right to attribute any kind of constructive knowledge on the improper use of the IDRL service. So, in totality, the court held that Record TV did not authorize any of the infringing acts, even if there were any, by the end user. So, the Singapore situation, or the outcome of the case in Singapore is very similar to the outcome of the case in the United States. Cable Cartoon Network and Record TV were simply the facilitators which provided the technology to allow the end user to digitally record a free-to-air or commercially available TV program to be viewed at a later time, and that such acts by the end user did not constitute public communication to the public. Right. Then we have the Australian version now. All right, the situation in Australia. What happened in Australia? Here, Optus was a group of companies that provided communication services, and one of the things they provided was to enable a subscriber to have free-to-air television programs recorded and when broadcasted, when played back at a certain time of the subscriber's choosing, and they could be watching it on their own mobile device or personal computer. So it's the same thing. Optus provided a kind of service which enabled their subscribers to record, all right, free-to-air programs and watch it at a subsequent time. Now, of course, you know, Australia is a great sporting nation, so it was expected that many of these customers would use Singtel Optus service to record and view games from the Australian Football League and the National Rugby League. Right? If they were not at home, they could watch it later on their television set, on their mobile phones or on their PCs. However, the two leagues had already granted Telstra, which was a competitor service provider, the exclusive internet and mobile rights to these games. So, they sued Singtel Optus for copyright infringement using the same arguments that was raised in Cartoon Network and in the Singapore Record TV case. And if you look at the provisions of the Australian copyright, they are very, very similar to the provisions in the Singapore Copyright Act, and conceptually, they are very similar to the provisions in the US Copyright Act. Again, you talk of being able to make a copy and also the right to communicate the film or that copy to the public. Right. There is also a similar provision on recording solely for private and domestic use. So that is an exception to the rule that it will not amount to an infringement if it's made for private or domestic use. And the same exception is also found in the Singapore Copyright Act. So, the main issues in the Australian Singtel Optus case, very similar. Who was the maker of the copies of the film? Who was the maker? Was it Optus or the subscriber? Right? And whether or not, if it was Optus that was seen to be making such film, whether or not Optus could invoke the defense of private and domestic use under Section 111 of the Copyright Act. So these were the issues that were addressed by the Australian courts. Very interesting. Looking at the definition of make, at the end of the day, the court came to the conclusion that the maker of the copy was either, they were not very affirmative, but they say it was either Optus or it was not Optus, then it was Optus and the subscriber, right? Which was a very, very different result from the Australian and from the US and Singapore courts analysis. The court held that Optus' role in the making of a copy was so pervasive that even though entirely automated, it cannot be disregarded when the person who does the copying is be identified. So it doesn't matter. They were part of the same unit, the facilitator as well as the end user, right? They went on to say the system performs the very function for which it was created by Optus, even if one were to require volitional conduct proximate to the copying. Optus creating and keeping in the constant readiness, the TV Now system would satisfy that requirement. So, notwithstanding the volution argument that was raised, because obviously this had found favor with the US and the Singapore courts, the Australian court seems to say, no, it doesn't matter. You know, you had it on all the time. You're providing this service all the time. You know, it doesn't matter whether there was an act of volition or not. You were guilty by association. All right, to put it very simply, that was the Australian court's decision. And the subscriber, by selecting the program to be copied and by confirming that it is to be, can probably be said to be the person who instigated the copying. Yet it is Optus which affects it, because without Optus involvement, nothing would have been copied. It's interesting how the same argument is twisted around, because in the Cartoon Network and in the Singapore case, you've got the static machine or the static facility, and both the courts say that you needed the volition act of the end user to make the copy. The Australians are saying it doesn't matter. The volition act of the end user would have no effect if not for the machine that makes the copy, right? Or the facility that makes the copy. So it was a reverse, it was a totally reverse way of looking at the issue. So, in the consequence, both Optus and the subscriber are jointly or severally liable for making the copies. So you got two joint tortfeasors here. So what happens then? Obviously, for the end user, he could rely on the defense of private and domestic use. So Optus then tried to say, if the end user, if we are both joint tortfeasors, then we should both be entitled to rely on defense of private and domestic use. But the court said, no, you can't rely on that section, because Section 111 of the Copyright Act allows for the making of copies of copyright work for personal and domestic use, whether or not these copies are made in a domestic setting. But there is nothing in the language or the provenance of Section 111 to suggest that it was intended to cover commercial copying on behalf of individuals. And that is what they said Optus was doing. Optus was running a commercial service, because it was paid for by subscribers, to allow subscribers to make copies for personal and domestic use. So, and he went on to say, the natural meaning of the section is that a person who makes the copy is a person whose purpose it is to, as prescribed by Section 111. Optus may well be said to have copied programs so that others can use the recorded program for the purpose envisaged by Section 111. Optus, though, makes no use itself of the copies, as it frankly concedes, it merely stores them for 30 days. So you end up with an anomaly here. The court is saying Optus and the end user were both liable for making the copies, but the end user can avail to the private and domestic use exception in the Copyright Act, but not Optus. So you have an anomaly here, and so Optus was found liable for copyright infringement. Right. So that was the decision of the Australian court. So where do we stand? How relevant is copyright law? Three different copyright regimes, conceptually the same issues have arisen, and yet the courts have treated it differently. I think if you look at it, both the Singapore court and the US courts have ruled in favor of the technological advances which are in the public's interest. Both courts agreed that time-shifting recording system did not infringe any exclusive right under the Singapore-US Copyright Act, right? But the Australians took a very different role and different position, and ruled that it was ultimately established that Optus' role in making the copy by embodying it on its hard disk, although automated, was so pervasive as to make it the person making the copy. Unfortunately, in Australia, that's where it ended, because they did not obtain leave to appeal to the High Court of Australia, which is the highest court, equivalent of the Supreme Court, and that's where we are. So, the question that I thought I'll leave with you is, how relevant is copyright law today, right? Can it still be used to protect your copyright in the face of technological advancement, right? This is what the Singapore Court of Appeal has stated, and I think it's something that is likely to be followed in many other courts and jurisdictions too. Where the Copyright Act is unclear as to how much copyright protection ought to be granted to a copyright owner, the court should not be quick to construe a statutory provision so liberally as to deter or restrict technological innovations by preventing them from being applied in a manner which would benefit the public without harming the rights of the copyright owner. Right. So what the courts is saying in both the Singapore and the US courts is, I think you have to, if it's not legislated, if it's not prohibited by the Copyright Act, then the court should be a bit more liberal in allowing or not restricting technological innovations. So that brings me to the end of a tale of 3 cities, 3 countries, how the courts have treated almost similar issues very, very differently.